Hi everyone, and welcome to part 2 of this 2-part series on prenups. So getting a prenup is like getting a colonoscopy. It's painful and stressful for a short time, so you don't have to have pain and stress for a long time. Indeed, a prenup is like a scope into the bowels of your finances. And the way I think about it is that marriage is one of the biggest financial decisions in your life. And like other big financial decisions in your life, such as buying a home, getting a loan for school, you sign a contract to know what will happen in case something goes wrong. So in this part of the video, we talk about what can be covered by a prenup, the ways spousal support can be paid, and how ironclad are prenups exactly. If you have any questions or a story to share, please leave us a comment below. So let's kind of focus a little bit more on the things people can put in a prenup, because in my experience of getting a prenup, I noticed that the things that your prenup can cover is pretty wide in terms of the range. And I feel like my own process of getting a prenup is kind of like an exercise in coming up with all of these different clauses for different scenarios and potential tension points in the future in case of divorce or death, and how do you divide the finances, how future kids might be educated or raised. So for example, if you want the kid to be raised in a certain cultural setting or to go to a certain private school, talks about what happens to pets and inheritance. So maybe just if you can, would you be able to go over some of the things that can and cannot be in a prenup? If there's like a list somewhere, some surprising ones that you've heard about.
Yeah, so I'm going to share my screen again and show the table that I've created. So this table outlines high level what can and cannot be included in a domestic agreement. So what can be included and we typically include it in, when I mean what's included in the prenup, by the way, it's what you can exclude later on from equalization payments. So the other spouse cannot claim any equity in that asset. So it could be bank accounts, personal and savings. It can also be any corporate bank accounts, investment account if you invest in Questrade or your professional corporation invests in Questrade account, any tangible property, jewelry and so forth. A lot of people exclude. I had a guy that bought a really expensive 911 Porsche 911 before marriage, and he specifically wanted to exclude that in the prenup agreement, so that can be excluded.
I guess if the
Any real
other party
estate,
agrees, right? If the other partner agrees, then
yeah,
sure, okay, you can exclude it. Yeah.
yeah. Some people have a collection of watches of, I mean, a lot of money, sometimes $500,000. So they want to exclude that specifically in the prenup, totally fine. Any real estate, again, that is not a matrimonial home for married couple, because matrimonial home cannot be excluded in the prenup. It will be shared between the spouses. Any RSP, life insurance, equity in a professional corporation, specifically for physicians, I always include it in a prenup. Any professional corporation or a holdco or anything that is related to their profession. Again, spousal support, you can waive it altogether, you can leave it in, or you choose midway, you can cap it, the number of years, the amount, very flexible. Any inheritance you get or receive before marriage and during the marriage, gifts from family, and then any future corporation, joint venture, or partnership. And I know this one comes out quite a bit in the physicians finance group, whether you can exclude future assets. Yes, you can. You can include it in the prenup and say, well, in anticipation of my profession, and I'm anticipating to set up a professional corporation, I would like to exclude it, and this is okay, and this will be honored. Whatever cannot be included is, again, the matrimonial home for married couples, child support, and any parenting arrangement. Parenting arrangement, I mean parenting time. It is very hard to set up ahead of time what's the custody going to look like, just because you don't know when you're going to separate. So I had, for example, a case where the parents separated when they had a 6-month-old baby. The baby is going to stay 100% of the time with the mother because they're still breastfeeding. So even if they come to an agreement that the baby will maybe they had a prior prenup, that the baby will be, or the child will be 50-50 with the parents. Because of the situation right now, it's not possible. So you cannot predict where the children are going to be, but you can predict and you can agree on how you're going to raise the children, for example, culturally, and just generally how you're going to raise your children. Like if you want to speak a certain language at home, if you want them to attend to any, like for example, institution with you, whether it's a church, a mosque, a synagogue, whatever, on a certain day, then you can agree on it. But, and this is the big but, at the time of separation, this provision may or may not be honored based on the best interest of the child. So the best interest of the child will always be first.
That makes sense. Thank you for sharing that slide. I'm actually curious, what is the role of debt in a prenup? Because let's say if someone comes in with quite a lot of debt and the other partner may not have any debt, and in the end, let's say the partner with the debt, they might be a medical student who ends up becoming a surgeon. Maybe the other partner without the debt might end up going into, let's say, a social work where the income is a bit different. So now there was this debt in the picture. How can prenups either prevent someone from being responsible for another person's debt, or can a prenup allow someone who helped pay down one of the partner's debt to get some income back in that case?
Okay, so as a debt, it is kind of special because it's there's a lot of arguments about that, who owns what to whom. So technically speaking, if you own a debt before marriage and at the time of separation you still have this debt and the debt is under your name, you're solely responsible for paying this debt. Things get very murky when someone comes with debt before marriage, for example, from medical school, and during the marriage the debt is settled, and let's say it's settled over the course of 10 years, but also the debt is settled, which means both spouses contributed to that settlement of the debt. But the MD spouse, if they marry a non-MD spouse or someone else that makes a lot less than them, the MD spouse can say, well, yeah, we covered the debt together, but I'm also making like 400K more than you. So there is they have a strong claim for this. And technically, I think that the non-MD spouse that maybe helped settle the debt would have no claim at the time of separation, because when you marry, everything is being joined together. And again, it really depends on what you do in the prenup. And going back to the model of finances, whether you combine all your finances, you keep them separate and traceable, or you do something hybrid, the claim would depend on which model you choose. But this can also be addressed in a prenup. So in a prenup, you say in your assets and liabilities, I have this debt. If we separate within 10 years, spouse number one with this debt will be solely responsible for paying that debt. So every financial arrangement between the spouses can be put into words in the prenup or cohabitation agreement.
Gotcha. And also it sounds like the prenup can also be used to protect future income in the case of the medical student who might have a lot of debt but earns much more in the future as well.
Yeah, and I would like to clarify this point because I think there's a lot of confusion between protecting income and protecting equity. So you cannot protect your income in the future. So for example, like for when you calculate spousal support or child support, you cannot, your income is going to be whatever the professional corporation makes or whatever a person makes. You're not protecting your income, you're protecting an equity and an asset. So, for example, if you own a professional corporation that didn't exist at the time of marriage, but now at the time of separation, it has $2 million in it, and it was specifically excluded in the prenup, then the other spouse wouldn't be able to come after you and say, well, I am eligible for equalization payment, so you owe me $1 million from the corporation because it's 50%. So again, you're excluding the equity in an asset and the appreciation of that equity of that asset, but you're not excluding your income. So specifically for doctors, and actually everyone who owns a professional corporation, can be lawyers, accountants, so forth. Whatever corporate income you're making, this will be deemed to be your personal income when you calculate spousal support and child support. So for example, if you have a PC that generates $500,000 a year, but you choose for some reason and tax deferral purposes to only remit yourself $100K, the judge will impute the $500K on you when they calculate the amount of spousal support and child support. And the notion is that whatever is in your PC or any corporation that you have control in, the money is available for you, and therefore it will be considered your full income.
Interesting. Okay, so that 500,000 will be used to calculate spousal support and child support, but a prenup can also protect the PC at the same time. So I guess you have to, so it's not like you can use your PC to retain assets and make your salary look lower, is what you're saying.
Right. And again, it's only what, so the equity in the PC and any other corporation will be protected. There is not going to be equalization. So that's equalization. But for the purpose of calculating what income should I use for spousal support and child support, then the corporate income is going to be imposed on that person. Again, income is what you're making per year.
Yeah.
It's not whether you have $10 million, because that's equity in the company.
Got it. That's very clear. So I also read about how prenups can also protect future investments. So I'm kind of curious, let's say if you already have 100,000 in Apple stock pre-marriage in your corporation or in whatever investment account you have, and then after marriage, 10 years later, it grows to $1 million. Does prenup protect future growth of those investments in your taxable and non-taxable accounts after marriage?
Yes, for sure. So when we do prenup or cohab agreement, each person, each spouse has a schedule, and they list all their assets and liabilities at the time of signing the contract. So if at the time of when you sign the contract, you have 100K and that 100K is excluded, then we're excluding the 100K plus any income, capital gain that that are derived from that source, if that makes sense.
That
so
does.
If the Apple stock grows in 5-10 years, then the entire amount, the base amount plus any appreciation, is excluded. And further to that, there's also the notion of tracing. What does this mean? It means that, let's say you have Apple stocks that at the time when you signed the prenup were worth $100,000, and now when you separate, it's $200,000. They're excluded. Let's say the day before the separation or a week before the separation, you actually liquidate those 200K. You withdraw them from your your investment account, and you buy a Porsche 911.
Okay.
This Porsche 911 is also excluded property. Why? Because if you can trace this money to the specific source, and if the source was excluded, then anything after that is also excluded. But it has to be very clear that you can trace the money directly. It is very easy when you do money transfer or keep the money in a separate account, because you can directly trace it to the new asset.
And so if you bought more Apple stock, let's say after you get married, then in those cases, it is not protected by the prenup, and it would just be divided 50-50, even if it was in your corporation?
So it depends. Well, if you exclude the entire company or the entire corporation, then it's excluded because it's an investment of the corporation. If, though, for example, you invest in cash GO and you get dividends every month and you reinvest those dividends, this is considered the appreciation of the account. So everything will be excluded. So all the equity in that account are excluded. Now, things get a little murky when you have stocks, and then let's say you have a joint account with your spouse and you take money from that joint account and you buy more Apple stocks, because now the other spouse can say, well, you used my money to buy the stocks, so these stocks will be divided 50-50.
I see. And in your RRSP and TFSA, all of those, if they happen to be excluded by the prenup, it would be treated the same as in the corporation.
Yeah, we'll specifically exclude any RSP accounts. Yeah, everything the
Gotcha.
company owns, any investment, the source has to be excluded. Yes.
Got it. And so the third thing about prenups that they protect is around inheritances. So in the case where, let's say, two people are getting married and the wife's parents leaves them inheritance in the future, it looks like the inheritance is also something that can be protected by a prenup. However, what are some things that you want to be careful about to keep the inheritance protected that you want to tell the audience about?
So there is the status quo is that any inheritance you receive during the marriage is excluded.
Mm-hmm.
But I always, always, always advise people to, and I actually automatically include it in a prenup to avoid any future claim or doubt. The only exception is, and this is something that people have to be very careful, is if you receive inheritance money
Mm-hmm.
during the marriage. So let's say one spouse receives 100 or 500K from their parents who passed away, and they take this 500K and they use it for the matrimonial home.
Yeah.
So they either buy a matrimonial home, or let's say they renovate the entire matrimonial home and the home appreciates in value. The matrimonial home is a black hole. Whatever you dump in there, it doesn't matter that money was excluded. It doesn't matter if it comes from inheritance. It doesn't matter if it comes from gifts from family. Whatever is dumped into the matrimonial home is automatically equalized 50-50 between the spouses. So think about the matrimonial home as a black hole. Whatever you put in there is gone.
Mm. So we actually touched on, so in terms of the next topic, we actually touched on spousal support quite a lot. Like we talked about how it's calculated and how in the status quo it is paid out and how it has like a time limit, right? Are there ever any situations where spousal support is not time limited? Like it might be lifelong, for example?
Yeah, so there is the 65 rule. As I mentioned, typically spousal support is paid for half the duration of the relationship from the moment you became common law partners. However, if you calculate that half, so for example, if people have been together, let's say they've been married for 12 years, they didn't live, they didn't enter into a common law relationship before. They've been married for 12 years, 12 divided by 2 is 6. When you add the age of one partner, so let's say they are, let's say 60 years old, they separate when they're 60 years old, and you add the number of years which they should get spousal support. So 60 is their age plus 6 years. It's the age of 66. If you cross the age of 55, which is age of retirement, then the other spouse has to pay the lower earning spouse spousal support for the rest of their lives.
Got it. So that's the 65 rule after the age of 65.
Yes, it's not very, I mean, it's not very common, but it happens. And again, you can exclude this in a prenup if you cap spousal support.
Gotcha. And I know you touched on lump sum spousal supports as well. How often do you see this being done? And in which situation would you want to have a lump sum spousal support?
So lump sum spousal support, usually it's great because it gives a spouse a clean break and an immediate release from any further claim. Typically, I don't find it in prenups just because you don't know how long you're going to be with your spouse. But when people separate, I find it quite a bit. So when they get a divorce, they just agree between them, well, okay, you're going to leave me a lump sum, or you're going to leave me the house. The house is equity, and this is how we're going to settle spousal support. And it's amazing because you don't have to revisit what the income of the spouse every couple of years, and there's no fights about there are no fights about how much one spouse has to pay the other. It's just a clean break. The only thing they have to know is that a lump sum is not tax deductible.
Okay.
So for a spouse that pays spousal support, whatever if they pay $500 spousal support to their lower earning spouse, these $500 are tax deductible for the payor, but for the payee, it's like they have to add it to their income. So it is taxable in the hand of the payee. With lump sum, it's not tax deductible, and it's also not considered any taxable income because it doesn't have a source.
That's interesting. And I also, moving on to like child support, I understand that child support is not taxable to the recipient. Is that correct?
That's correct, because it's the notion is it's child support is for the benefit of the children to raise the children.
Yeah.
It's not considered any taxable income.
Gotcha. And in terms of the components of the child support, usually you would have a basic amount and then a Section 7 amount. Can you touch on the Section 7 amount a little bit and what that means?
Yeah, Section 7. So there is the child support base is what you pay, and then Section 7 expenses. Typically, they're shared equally. What is Section 7 expenses? It's usually things that are just extra. It can include if the child goes to private school, then their tuition fees. They go to universities, the tuition fees, any summer camps, if extracurricular activities, if they get private tutoring, and all this kind of stuff that you deem as extra. Typically, they're supposed to be shared equally, but in my experience, usually the higher earning spouse contributes more to those Section 7 expenses. Also, in the case of children with any disability that need maybe a special treatment or attend a facility, and this costs more money, it's usually quite expensive, then this is included in Section 7 expenses, and it will be divided among both spouses.
And I would think Section 7 is hard to determine, right? Because you can technically enroll your child in as many things as possible, or choose the most expensive private schools and so on. So how do couples kind of like determine this expense when it's really hard to know what your child would end up being enrolled in later on?
So typically, it's a good question, and it's not very clear. I mean, usually the parents sit down together and they create an Excel sheet with everything that the child is enrolled in. And then they kind of calculate how much each will contribute. Technically, when you separate, get a divorce, and both parents have decision-making responsibility, then one parent can enroll a child to an extracurricular program without the consent of the other parent.
Gotcha. That makes sense.
Yeah. So both parents have to agree. If they don't agree, then they go to the court, they start fighting. It just creates a lot of stress, anxiety, and more legal fees, and I don't advise it. So I always tell them just agree on something. Typically, usually agree on what they want the kids to do or enroll in.
Gotcha. And so usually child support ends at around 18 years old, but you had mentioned one situation about if a child has a disability, the child support might last longer than 18. Are there any situations other than that where the child support might go longer than 18, or maybe it ends earlier than 18?
Yes. So there are variations to this, and it's kind of funny, but there is discrimination between children of divorced parents and children of undivorced parents. So children of divorced parents, both parents are actually legally obligated to pay any university college tuition fee for that child, even after the age of 18. Even if this child gets an MBA when they're 26, the parents have to contribute to the best of their financial ability to the tuition of the child, because there is this notion that children of divorced parents are more vulnerable, and therefore the parents have to support them. So the parents have to continue paying child support and Section 7 expenses. There is a variation, and it's actually comes up quite a bit. So one parent can say, well, what if the child is over 18 years old, they attend college, but they work full time? the parent actually has a strong claim because they can actually take the income of the child that works full time and deduct it from child support or any Section 7 expense payment that they're going to pay. Also, if this child, let's say, attend college and the tuition is 10 grand a year, but the child gets some grants from school such that the tuition is only 3K a year, then the parent has a strong claim for this because they're actually going to deduct everything that the child gets in terms of income or grants or bursaries from what the parent has to pay. Because the notion is like, okay, you don't need my support anymore, or to the same extent. Anymore because you have a job, you're earning income, and you're getting all these grants.
Gotcha. And finally, a lot of questions people ask is around how ironclad are prenups if they can get invalidated by the court. What are some common reasons for a prenup to get invalidated?
So a lot of prenups get invalidated, not a lot, but it's some prenups get invalidated because the parties failed to disclose their assets and liabilities. And again, it's not that the entire contract is invalidated, it's just that it can go against the spouse that did not fully disclose. Also, some people may, again, it's harder to prove when the prenup and cohab agreement that one party experienced duress, which is basically someone pressured them to sign the contract, and therefore the presumption of informed consent is invalidated. It's a harder claim because usually people sign prenups or cohab agreements when things are good and they agree on all the terms. So it's pretty hard to prove that. Some clauses in a prenup can be invalidated in very specific circumstances. For example, if the spouses waived spousal support altogether, 20 years later, there is an MD and non-MD. So the MD now makes $500,000 a year, and they separate from their spouse. Their spouse is non-MD and involved in a motor vehicle accident, and now they're on a wheelchair. They will have a very strong claim to invalidate that waiver of spousal support due to unconscionability, because they're going to say, well, I waived it back then, but now there is a very significant change in circumstances. I'm in a wheelchair, I'm not able to earn any money, and this person is now making $500,000 because, so I don't see any judge that would really not invalidate this clause. Again, it's harder to prove, and there need to be a very dramatic change in circumstances, but there could be a case of unconscionability between the spouses, even though they agreed on something else 20 years ago.
Gotcha. That makes sense. And I know that there are some people who talk about also getting a post-nup agreement. Are post-nup agreements more likely to be invalidated than prenup agreements?
The answer is yes. Again, it's harder to invalidate an agreement, but as I mentioned, prenups and cohab agreements are usually signed in the beginning of the relationship before the parties really accumulate a lot of equity, or at least they have less equity.
Yeah.
So things are good. And so both parties provide consent and agree and so forth. With marriage contracts, so it's signed after you get married, people sign an agreement typically because something is not right. Maybe the relationship is going south, and usually it's one spouse that pushes for signing this marriage agreement because things are not good, and maybe they're anticipating divorce. So in this case, I always advise both sides to get independent legal advice. And I usually don't represent them jointly. So with prenup and cohab, I can jointly represent someone. But with marriage agreement, I advise each side to get their own independent legal advice such that the other spouse won't be able to claim any duress or unconscionability later on. But so there is a higher chance of them getting invalidated. But again, it's very hard to prove this because you really have to prove that you were drunk at the time you signed the contract, or there is some duress, or you experienced some maybe mental health or physical, some mental or physical thing in your life, it's harder to prove, but the probability of invalidation is greater.
You had mentioned earlier that for a prenup, sometimes you represent both clients jointly. I've read a lot that it's actually better to have separate legal counsel. So is that something you would still recommend as well? Like just making sure that in a prenup situation, each person gets their own independent legal advice?
So as a lawyer, I have to advise people to get their advice, their own legal advice. But I'll be honest, it's completely okay to represent both parties. Again, a lot of physicians from the group come to me and say, hey, we're two people, we agree on all the terms. They actually like send me whatever they want to exclude already. They agree on everything. They just Noa just put it on paper for us.
Got it. Okay.
Totally fine. But I make sure to tell them, listen, if there is a disagreement between you, I cannot advise either of you. I cannot favor one over the other, and I cannot keep things confidential. If one spouse gives me a call, I cannot keep it confidentially from the other spouse. Everything has to be shared, and I cannot discriminate between them. So yeah, you can be jointly represented. It also saves legal fees because you don't have to start negotiating. And most people come to me when they already agreed on all the terms they would like to include. So this is completely fine.
Gotcha. So I did have a question about cohabitation agreements because I know that we touched on it quite a bit in the beginning with the case. In a case where you have a couple and they've dated for a while and now they want to move in together. And let's say each individual in the couple have their own homes, like they own their own homes already. What is the best course of action in deciding whose home to move into? Given that once they choose one person's home, it becomes the marital home.
So specifically for a common law partner, as I mentioned before, there is no equalization of properties. So whatever, you don't have to share any assets that you come to the relationship with and after the relationship ends. So even if you move into a home that is only owned by one spouse, and this one spouse is on title, the other spouse would have a very hard time claiming equity or percentage of equity in that home because common law, there is no division of assets.
Gotcha. Okay.
Yeah, but I would still advise to get a cohab agreement just to remove any doubt and waive the unjust enrichment claim that one spouse may have in the future.
Gotcha. And if that couple do decide to get married, then maybe they'll have to have that conversation about, well, whose home it's going to be. That becomes the marital home, it seems.
Right. So when you get married, then the notion and the concept of matrimonial home kicks in. Again, it's not that a lot of people ask me, well, the date of marriage, that means I owe 50% of the house of the other spouse. No, the judge does have discretion. It's not like you get married automatically 50-50. It's over time. I want to say 3, 4, 5 years, depends how interdependent the relationship is, depends if there are children and so forth. But what a lot of people do when one person owns a matrimonial home or a home and the couple moves into this home, then they can't exclude it in a separation agreement. But for example, what I tell them is like, okay, if you live in this home for the next couple of years and then you move into a different home, then this home will not be the matrimonial home anymore. Another thing you can do is before marriage, the spouse that is on title for the house actually has a trust declaration, and they're basically declaring their own, they keep the home in trust for their parents. So technically the spouse is the legal owner, but the beneficial owner are the parents. And so it's kind of hard to make a claim for this. Another thing spouses can do, which is, it's kind of annoying, but basically move into a neutral space, rent out that home that one spouse owns and exclude it in a prenup agreement. and just live in rental property or buy a property together. Totally up to them. But
Gotcha.
it's definitely a tricky situation.
Yes, for sure. So we discussed a lot of cases today. So I'm just going to move on to some rapid fire questions. These just can be answered in a line or in a few words. The first question is, with so many lawyers out there, how do people go about finding good family lawyers?
Seek recommendations from your friends, read reviews, look at someone who has experience drafting domestic agreements for physicians. And if you're interested, you're very welcome to get in touch with me.
For sure. Second question, what is your best relationship advice for audience members?
Just be best friends and have common hobbies together so you can experience life together and communicate openly with each other.
Okay, and number three, on the opposite side, what is a red flag to be aware of in relationships that you've seen and in divorce?
Poor communication, and spouses' inability to sympathize with one another.
Mm-hmm. Number four, what is the range of costs for prenups / cohabitation agreements versus a divorce?
So this really depends if the couple is jointly represented, they're separately represented. It depends how customized or complex the agreement is. And it also depends who is the lawyer that's drafting the agreement. So large firms will charge more than an independent practitioners. So for example, when I draft a cohab or prenup agreement, it starts between 1,700 to 2,000, but that's the price in Toronto, but it really depends again on all these factors. It may be higher. But it's important for me to mention that there are some physicians that came to me after they've been quoted 4 and 5K for a domestic contract. So just do your due diligence and make sure that you're not being quoted or over quoted just because of your job title.
Right, right. And how much would you say like a divorce might cost?
Oh,
could be a lot, right?
It really depends. If you jointly represent, and do you have claim for property, spousal support, child support? Do you agree or do you not agree? Are you jointly represented? It can be as simple as like $6,000, and I've heard on divorces that go to 100K. It just depends how much work you give the lawyers.
Yeah, that is true. Yeah. And finally, what is your favorite resource on marriage advice? Could be a book, podcast, anything.
So my parents are my role model. I was very lucky to grow up with parents who are really, really best friends. They went through everything together, including immigration, which typically makes or breaks a relationship. So they're my role model.
Wonderful. Well, thank you for joining Noa on this series about prenups and cohabitation agreements. So if you have a question or story to share, please leave me a comment. And if you want to reach out to Noa, how would folks be able to find you?
Able to find me through the Facebook group, the Physician Financial Group, or email me. Would be happy to chat.
Sure. And I'm happy to put your email in the description as well. Well, thank you, Noa, for joining me today and for answering all of the different cases that we talked about, and the slides that you presented in the beginning were really helpful. So thank you so much.
Thank you, Steph.